Hello and welcome. My name is Devin Easterlin and I'm the CEO here at SJA Property Management. Today we're going to be having a discussion on House Bill 1217, otherwise known as rent control in Washington State. We'll be going over some of the highlights of that bill and how we plan to stay in compliance here at SJA. Joining me will be Harry Matsumoto, our Director of Operation. Harry is a wealth of knowledge when it comes to the new regulations that are being imposed on housing providers, and he's going to enlighten us on some of the finer points of the bill and how we plan to stay in compliance. Just as a reminder, this conversation is for informational purposes and not to be construed as legal advice. We would definitely recommend that everyone seek legal advice from a licensed attorney to help navigate them through these various changes. All right. Harry, why don't we get started by you telling us a little bit about what you do for the organization?
Well, hi, Devin. I'm glad to be here. This is a very important topic to talk about. My role here is to really ensure smooth operations, scalable operations for the company, ensuring we have high delivery of property management services, and importantly, keeping our clients and the company in compliance with the laws and regulations that are implemented from time to time here in the state of Washington.
Yeah, it seems like that's always a moving target, especially where we are. We don't have sort of a statewide mandate on how to manage property or how to be a landlord. It varies city by city often, so we're constantly working on our processes and procedures to stay in compliance on behalf of our owners and make sure our residents, everything is working correctly and how it's supposed to. So I know that's a big job, and especially when you're doing it at scale there like you are. I think currently we're managing around 1,000 units, and primarily those are small buildings and single family homes. So a lot of residents and owners to take care of there. So I really appreciate all that you do for the organization. Well, why don't we jump into a little bit, Harry? Why don't you talk a little bit about some of the highlights of House Bill 1217? What are some things that are how has that changed? How housing providers are going to need to be operating?
Yeah, so House Bill 1217, commonly known as the Rent Control Bill, passed and signed into law on May 8th by the governor. Imposes some restrictions on landlords that some would consider egregious, but it is where we are today, and it's following suit with a lot of other states. Some of the highlights for this new law include restricting a landlord from raising the rent in the first 12 months of an initial tenancy, and then subsequent rent increases are restricted to the lesser of 10% or 7% plus the CPI published by the Bureau of Labor and Statistics. The law also increased the amount of time we have to give a tenant a notice of a rent increase. It was 60 days per the landlord-tenant law. Now it's 90 days. The one thing that's that they didn't do in this law is put a preemptive clause, and what that means is the state law does not override any other jurisdictions that require longer notice periods. So for instance, if your home is located in the city of Seattle, you have to still comply with the Seattle's requirement, which is 180 days regardless of the amount of the increase. So landlords have to be very focused on where their property sits and making sure that they're complying with the local laws. So for instance, another jurisdiction, unincorporated King County, up to 3%, you have to give a 90-day notice as well. And then they're over 3%, you have to do 120 days. So just making sure you know where your home sits, and if there are laws more restrictive than the state's 90-day law. The other thing
would you say, Harry, that basically as a rule of thumb with that, what I've seen is that the most restrictive one is the one that needs to be followed, right? So for your example of Seattle, they're requiring 180 days. And even though this new bill moves it from 60 to 90, we still need to comply with that 180. So the cities can still restrict even further how a landlord needs to be operating.
That's right. And the way I tend to look at it is anytime there's a jurisdiction that has a higher restriction that benefits the tenant, that's the one we're supposed to follow because that's typically how the courts would look at it. Another provision of this HB 1217 is they actually have a templated notice. So all landlords now have to use the notice that's that the legislators created in the law itself. They can no longer use their own format of a notice of rent increase. And that's not too burdensome, but it doesn't allow landlords to create a notice that might be a little more friendly, that might explain more about the details. So it takes away that level of freedom. The other the other requirement of this law is it creates parity between lease types. So before, landlords oftentimes will try to offer a much larger incentive for tenants who might sign a fixed term lease, a 12-month or 18-month lease, as opposed to a month-to-month. This law now requires that the terms and conditions of a lease must be substantially the same between these types of lease types. And if you are going to have a variance in the rent amount, that variance cannot be more than 5%. And regardless, you have to make sure you're complying with the rent cap restriction. So that's an important one to follow. And the one I think that probably is the most scariest component of this law is they put in an enforcement provision. The provision states that if, for instance, a landlord mistakenly raises the rent above the cap, the tenant must give the landlord an opportunity to cure. In other words, to pull back the notice and say, "Oh, we made a mistake. Your rent increase is less than the cap." Even if you do that, the tenants still can terminate their lease with 20 days notice anytime prior to the rent increase. If you don't cure, tenants can sue you, and there are damages associated with that. And even if you do cure the notice and correct your mistake as a landlord, the attorney general, regardless of what the tenant does, can still file a lawsuit for you based on the first notice that was an error in violation of the law. So it's a scary component of this law, the most scariest, if you would.
Yeah, I think that's a really good point that you bring up. It seems like they've put that in there as a pretty big deterrent to keep anyone from trying to, potentially not make these changes quickly. And what it does is you have a lot of our client base is new to investing or hasn't had rentals for very long, and they come to us to take away the burden of and the stress associated with staying up in compliance with properties, all the laws, all the new maintenance regulations, everything associated with having an investment perform effectively and keeping yourself out of trouble. However, many people are still doing it on their own. And I think this is where, if you are one of those people that is self-managing, you really have to educate yourself on this. Get a good professional to help you get set up correctly so that you can make sure that you, like Harry's mentioning here, you don't make a mistake. And then even if you correct your mistake, you're still potentially liable for a lot of negative ramifications from that. So getting it right the first time is going to be really important. And that just comes with education and making sure that you've got all your ducks in a row there.
One of the components of the law that I found interesting related to the cap is, the restriction that you have to be 10%, the lesser of 10% or 7% plus KPI. The law specifically states that the Department of Commerce will publish the CPI every year on June 1st. And the nuance to that is, So for June 2024, the CPI was 3.8%. If you add that to the 7, it's 10.8, which caps us out at 10%. And that is only valid until May 31st. So June 1st of 2025, because we're not expecting the Department of Commerce to publish the CPI until probably mid-July, to not risk going over the cap, you actually have to drop the cap back down to 7%, because you won't know for that 45 days what the CPI is going to be after June 1st, because we won't know until mid-July is what we're being told. So we're at a cap of 10% now until May 31st. The cap drops to 7% until we find out from the Department of Commerce mid-July what the June 1st CPI is. So that's a nuance in how to keep in the back of your mind when you're thinking about raising increases around this time period. And that's something that we have to build into our systems to ensure that our team are not stepping over the cap.
So looking like that you need to take the most conservative approach with that until we do get real numbers.
Yes, and that we take that conservative approach, especially in light of the enforcement requirements that they put into the law.
Well, in your estimation, you've been in the real estate industry for a couple decades. I won't age you here, but you've been in it for a while, as have I at this point. What do you think they were trying to accomplish by this passing of this bill? What was, I believe that there are some, they're trying to get some positive outcomes here. What do you think they're thinking about?
I think, the legislature, at least in the preamble of the law that I read as they were working through this over the last 90 days, suggest they're focused on runaway housing costs, especially in the rental area. And their intent really seems to be to try to keep rents from running away and making housing unaffordable in the state of Washington. And many cities and jurisdictions have tried to do the same thing, but the state, for the last 3 years, has attempted to make these rent controls come in different forms and fashions. The last 2 years, I think legislations have failed, and given the body of legislators that we currently have, they were able to make this law take effect. So I don't know if their intent is going to work, but that seems to be what they were trying to accomplish.
Yeah, I would agree with you. I mean, this is, what, regardless of how you feel about it, it's a attempt to lower housing costs that have really risen very significantly over the past decade here. And so I can understand that. I know from, being involved in different organizations and looking at how rent control has impacted other states like Oregon and California, New York to some degree, and the negative long-term effects of that. This seems to be that we could be in danger of having some of those. We've looked at it when we've analyzed the situation as more of a supply and demand issue, that we really need to spur more housing supply. We are woefully undersupplied, and we need to provide as much housing as we possibly can, then bringing down that demand and lowering out prices. And I know the legislature over the past few years has kind of nibbled around the corners on that, but hasn't done something meaningful enough to really spur that supply. And I think this is one of the major concerns, is by putting this regulation in place and putting essentially rent control on Washington, it's going to lower our ability and housing providers' ability to create new housing stock and lower people's appetite for investing in real estate. I think about it as we want to promote people to invest in Main Street as opposed to maybe Wall Street, right? Invest in their community. A lot of our clients, this is their retirement. They're choosing to have a rental or two as a way to make income in retirement. And they're helping solve that affordability issue by having more supply on the market. And if you say through rent control or other things that may make it more risky or less advantageous to own real estate, they can easily choose to say, well, I'll just go put that into a 401k. I'll just go put that into equities or bonds, something like that. So hopeful that doesn't come to pass, but if history is any guide in these other states, it has not been the solution. Even if, the heart's in the right place of lowering housing costs for folks, we can definitely understand that, but I'm not sure that this is the solution. We will see. Time will tell with this as we navigate it. So right now, we're dealing with the here and now. And again, we're trying to implement and get our processes and procedures in place so that we are in compliance. We've already touched on how important that is. So what are you working on right now, Harry? How do we have to adapt as SJA, as a company, but also as other housing providers out there?
So right now, SJA, we have internal systems and workflows that already allows us to implement rent increases on a regular basis, to do all our renewals. In response to this law, we have to adjust those workflows, one, so that we're complying with the requirements of using the notice that the state now requires, making sure we comply with the timelines that exists in the jurisdictions that have more restrictive timelines for giving notices. And then we're always working on trying to streamline so that we can eliminate human error by using technology, for instance, that'll automatically calculate what rent increases are, the percentage. It will know based on the percentage what timelines we have to follow and what jurisdictions. So making things easier for, in light of the complexity of the law, still making it easy for our teams to do their work well, to serve our clients, and to make sure we stay in compliance with the law.
Yeah, and I know from our standpoint, we are not looking ever to maximize our rental renewals. Our job and what we feel is to be advocates for our clients. And really our philosophy here, and I think is a good one, is a sound one for everyone to follow, is we want our tenants to feel respected and to stay in the properties as long as possible. We're not looking for turnover. So in order to do that, we're not looking to have unreasonable rent increases. However, we're also balancing the fact that our owners' costs are going up. So maintenance costs have gone up over 10% in the past couple of years. Property taxes, I don't know about you, Harry, but I received a large property tax increase, right? So this really does impact our clients and investors in general. All of their costs are going up, but now they're really limited in how they can recuperate that in terms of generating more revenue with their properties. So it is a balancing act, but we're always looking on the side of trying to find win-win solutions, providing that great experience and a great quality housing for the residents, while still looking out for our owners' best interests, as those are our clients. So if you were a self-managing property owner, where would you put your focus right now in order to get up to speed on all this and to make sure that you are in compliance?
The best thing is to reach out to professionals, and that's the fastest way, because most professionals like SJA, we stay on top. We stay on top of the laws as they change, and we build our systems to ensure compliance. If you are self-managing, then one of your best bets is to make sure you reach out to an attorney who specializes in the landlord tenant law, because oftentimes when you read the new law, there are components of the law that don't stick out to you, that the attorneys can interpret based on precedents from previous, that will keep you in compliance. So, just reading the legislation of the law itself is not going to be enough. You need secondary interpretations, and so we work with industry professionals as well as attorneys so that everybody can put their heads together to make sure that we fully understand the law, the secondary and third effects of those laws, and how we might have to change our operations to stay in compliance.
Yeah, no, I think that's really wise. Even if you are someone that takes pride in managing your properties yourself, that's wonderful. I think it's still worth it to reach out to an attorney and spend a couple hours of their time going through how you plan on staying in compliance, making sure that the behaviors and the actions that you're going to take are in compliance with all these new regulations. It's going to be well worth your time. It may cost you, a few $100s to do that, but I would definitely recommend it for sure. There's also organizations that you can join that kind of stay on top of this, and just being really proactive, like we mentioned, getting it right the first time is going to be really important with this. So I would say reaching out to local attorneys that can help you with this if you're not looking for professional management services is your best bet there. One thing we didn't touch on, Harry, but I'd love to hear your thoughts on, there are some compliance issues in terms of how notices need to be delivered.
Yes.
So can you kind of enlighten us on what changes are there?
Yes, the biggest one, and I call it a companion legislation with 1217, is Senate Bill or House Bill 1003. That bill specifically amends RCW 5912-040, which tells the landlord how they're supposed to serve legal notices here in the state of Washington. The current law states that we can states how you serve notices, and one of the methods is to mail a notice to the tenants. And you can mail it from regular first-class mail in the county that we're in. On 27th of July, when the new law takes effect, that changes. The one flexibility allows us now is as long as you mail the notice from anywhere within the state of Washington, you're in compliance with that RCW and no longer restricted to the same county that the house sits in. So that's good. The bad part about this law, and more costly to landlords, is you now have to send when you mail a notice, you have to mail it certified mail, which, depending on what platform you use, or if you use the U.S. Postal Service, it's anywhere from $4.35 to $5.35 per envelope. And what attorneys are advising us is you have to mail, if you have a rental with 4 roommates, you're going to mail 4 separate envelopes, and then 1 additional envelope to addressed to any other occupants in that same home. So you can imagine sending 5 separate envelopes, certified mail, which costs your postage at 70 cents, and then $5.30 per envelope. So it really increases the cost and the burden for landlords. So those who are self-managing, you can imagine now you've got to run to every time you do a rent increase, you got to run to the post office, and you got to do all this certified mail. You got to make sure you're keeping copies of those in case you have to go to court, or if for whatever reason the Attorney General wants to make an inquiry because they got a complaint that you may have violated the law. You now got to demonstrate that you're in compliance with the law by showing that you've mailed it certified mail. So it adds another administrative tasks on landlords that makes managing properties a little more burdensome.
Yeah, a little more challenging. Some of these things with best intentions, when the application, it seems to it makes it a lot harder to stay in compliance, for sure. Definitely. Yeah. Well, thank you so much, Harry. I really appreciate you sharing your perspective. And I will say that this is not a comprehensive discussion of all of the intricacies of these various new laws, and definitely consult with an attorney to make sure that you are in compliance and have everything, all the details worked out. This is more of a conversation and how we look at working through these sort of never-ending changes from the property management industry here at SJA. But of course, we're here for you. If anyone has any questions or comments, feel free to reach out to us, and we'll guide you the best we can from the area of property management that we handle. So thank you so much, Harry. Really appreciate it. And we'll see everybody soon.
See ya.